Excellent.
Hey, Scott, I know Colleen coordinated with you getting an article over that I drafted, frankly, a long time ago, but has stood the test of time just because the relevant statute hasn't really gone through an overhaul, and it's dealing with the home improvement contractor statute. Is that available for folks, or how are you going to handle that?
I have sent it out, and I'm going to put it up on a website to put a link to it also.
Okay,
But
good.
everybody that signed up here has that.
Great.
So I'm just going to welcome everybody to our webinar today. It's our contracts and law class. So if you signed up for the 2 CEUs that are available, that's great. Thank you very much. We will document the fact that you're here, and we will send you that certificate so you can take care of your construction supervisor license renewal. And once again, I'm really glad to see Mike Sams available for this. Mike's a longtime member of Bragby, and I'm very grateful that he's willing to do this event for us. I'm going to make sure that for now, all your phones are on mute. If you care to be on the video, that's fine, but please try to keep your audio muted for the time being, except for Mike. We are recording this video. We will have it posted as soon as it is available off the cloud. So I'll send everyone here a link to that. And if you have any questions for now, send them to me in chat. I can intercede and ask Mike. Certainly you have the ability, I believe, to raise your hand, although I might have trouble noticing that. But we'll also open up the floor at the end of the presentation for questions, should any of you have those. And with that, I'm going to turn this over to Mike, and we're good to go.
Thanks so much for having me, Scott. I'm going to jump right in, and then I'll take a step back. I want to talk with you about this, the average life of a contractor. I was preparing for a program similar to this now, probably about, I don't know, 12, 13 years ago. It was before the Great Recession. And it said I was reading an article, and it said that the average life of a contractor is 7 years. And I thought, that's almost no life at all. And if you think about particularly high risk area, which is residential side contractors, the average life expectancy is even less. I really appreciate you guys, all of you, guys and gals, men and women, joining us here for this program. I know that you have a lot going on. It's been the craziest year. I think it's been much crazier than the Great Recession. It's been a year nobody could have predicted. And so I know you have a lot of things pulling you in different directions. Now more than ever, it's important that you focus on good risk management, because the reason that contractors have such a short life expectancy is bad risk management. I'm sure there's an odds and ends contractor that's just not good at what they do, but my experience is that more often than not, the contractors, the people that do the work, are good tradespeople, really fine quality tradespeople. The problem comes in managing the risk. And there's some folks who look at it from a perspective of, I can't invest in it. There's some people that look at it from a perspective of, I don't have an interest in it. What I can say to you, because things come to me all too often after they've gone badly, is that if you don't invest in your risk management, if you don't have an interest in it, that is, if you disregard it, it's going to come back and bite you. The question's when. You may have, it's not if, it's when. You may have 99 contracts that go well, but some of those have been by luck. And that one that comes to bite you, it's not going to be a $1,000 issue. It's going to be a 10 or a 20 or a 50 or 100 or multiple $100,000 issue. And that's where you need to make sure that you've got good paper, that you've taken good steps. It is the failure to do those things that shortens the life expectancy of contractors. So I've dealt with this for probably about 26 years now. Most of my work is dealing with contractors. I started out as a trial lawyer and sort of as I moved into doing almost all construction law work, I sort of backed into also being a risk manager. That is, I realized a lot of the same issues come up that lead contractors into litigation, a lot of the same things. And so I've as a lawyer and then as a firm, we do a lot of work ourselves on the risk management end to try to keep our clients out of litigation, because once you're in litigation and you're going to be paying your lawyers not thousands of dollars, but tens of thousands of dollars. And it's not because they're bad people. It's because litigation issues take a lot of time. And if you think about when you hire a lawyer on a construction law issue, it's like for you guys, it would be a cost plus job. And there's just a lot of time involved, and that drives the costs. So I initially started with a top 10 list when I first started giving this presentation, because everybody starts with top 10s. What I've realized over time is that there are a few more issues that come up repeatedly. And it's not to say that these are the only issues that you deal with as a contractor, but these are the issues that I see come up so often that they're things that you're crazy if you're not on top of managing these things. When I talk about these today, what I'm going to try to do is get away from the legal mumbo jumbo, or if I start with the legal mumbo jumbo, translate it into how it hits your bottom line such that you understand it's not a check the box issue. It's not a pro forma issue, that if you don't do these risk management things well, they are going to hit your bottom line, just like bad estimating would. So that hopefully through this process, you'll see I need to focus on these things. And there are some good ways to do it. And we'll be talking all about that today. The good folks at Bragby are going to be monitoring the chat line. So I'm open to taking some questions as we go with questions that are relevant to the different points that we're hitting. I want to make sure that you guys are getting the information you need. So if you have a question, you don't have to hold it till the end. I'll try to address it as we go, but we'll also have time at the end of the program. So let's get started. I'm not going to run through this list right now because we're going to run through it over the rest of the program. So the first couple risk points are a little bit more touchy-feely. Think about the way that you think about lawyers. You know, there's all those stereotypes out there. We're sharks. You've heard all the lawyers' jokes, but the similarity of all of those jokes is don't trust a lawyer. That's the stereotype. It's an inaccurate one, I think. Not to say there's not some bad lawyers. There's bad people in every profession, but generally speaking, it's not an accurate one. But there's this. I go through this because there's a very, very similar stereotype of contractors, and that is lay people not in the business of doing construction, the people you are contracting with. If you're a general contractor, or even if you're a plumber, an HVAC, or an electrician, and you're doing work directly at people's homes, you'll see that a lot of folks have this perception of you, that is, that you're pushing around wheelbarrows of money. It's all easy for you. It's just, pennies from heaven raining down from the sky. And like lawyers, you're not to be trusted. You're always going to try to screw them. That is a general stereotype that's out there of contractors, whether you know it or not. And so with respect to that, under this topic of building the relationship, mistrust is the leading cause of needing a lawyer. I point you to item number 2 on this list, and that is build the relationship. Go into your projects with the understanding that most people aren't trusting you. Doesn't matter if it's fair, it's reality. I deal with it with new clients all the time. That's how I start my relationships with people. I think they probably don't trust me. They probably are carrying into this relationship some stereotype that's not favorable. I need to dissuade them of the notion that I'm not worthy of trust. So there's a couple ways to do it. One is, and this is central, don't overpromise them. Never overpromise them. A central overpromise that I see is on time. You're inclined to tell them you'll get something done even when you've got some reservations in your own gut about it, and you think, well, it'll help me get the job and I'll figure it out as I go. Well, there's a lot of things lay people don't understand about construction. You know, you could have needed 3 change orders along the way for legitimate things, and you explain it and they agree to it. They sign off on it. But I'll tell you, most or a lot of them don't really understand, and they're signing it and they're thinking, I may be getting screwed here. This contractor is, I thought it was going to be they gave me a fixed price contract. I thought the project was going to get done for that amount. Already it's more than that. Just like my dad told me it was going to be. This contractor is going to screw me. But they're signing because they don't necessarily understand, and they're still trusting you a little bit. Once they see you're not hitting whatever your scheduling milestones are in your contract, that is something they know. That is something they know. You're supposed to be done with X by this date, and I may not have understood any of the other stuff as a layperson, but I can look at the schedule and I see you're not on time. Aha, I knew you were screwing me. Now, you may say that's not fair, but as we talk about it at my firm, perception is reality in the client relationship, and their reality can lead to, it will lead to either a bad result in that they're not happy, which is not good for you because they're not referring clients over to you. Or worse, they're withholding money at the end because they think you've screwed them somehow and they don't trust you. Or litigation. All of those things are bad things. So don't overpromise, especially on schedule. And explain the process to them as you're going. Keep them in the loop with what's going on the project. But let me go back to the first point on this slide. And that is, don't work with crazy people. I remember when I first started getting clients, and I was just so thrilled that somebody wanted to hire me for my legal expertise, and they were going to pay me to do what I really like to do. And I was thrilled. And I got hired by some people over the years that I thought, all right, this person seems a little bit out there. But we always do really good work and we get great results, and I'll make them a raving fan before this is all over. And what I learned from experience is the people who make your antenna go up as to whether they're crazy, you should trust your gut, trust your antenna that went up. They are crazy. And in your world, what they're going to cause you is an increased potential for litigation. They're going to make it hard for you to get change orders that you're entitled to because they're going to be fighting about everything. They're going to cause you a lot more in administrative costs dealing with them, and they're going to cause you a whole lot of heartache. If you think they're crazy, there's a saying out there, it goes something along the lines of sometimes the best job is the one you don't take. I commend that to you for this one. Because every time you've avoided a crazy person, that you don't have to call me or whoever your lawyer is to engage the lawyer to spend tens of thousands of dollars, you've just saved money. So avoid the crazy people. For those that aren't crazy, you got to develop the relationship. Assume they don't trust you. Go out of your way to develop the relationship. The best ways to develop the relationship, again, don't overpromise, but over-communicate. Over-communicate with them. If you're not communicating with them, you are sending them an unintentional message. And that message is, I don't really care about you. Now, you may say, there may be some of you out there that actually say, look, I didn't go into the construction business to really care about people. I love building. I don't really love the relationship piece. But if you're going to be a good business person, the relationship piece is a big part of it. I'll tell you, from having tried and arbitrated lots of cases, trial lawyers, what we always try to paint to a jury is there's the black hat and the white hat, the good guy and the bad guy. But the truth is, it's usually, most of the time, litigation results from hurt feelings and misunderstandings and gray. It's not black, it's not white, it's gray. If you avoid doing business with the crazy people and you work your tail off to develop the relationship, you've minimized the litigation chances. In fact, if you're not only doing good work, but you're working your tail off to develop the relationship, then when something goes sideways on the job, and I mean, almost no job is perfect, the owner will have some trust in you. It'll minimize the chance that future thing that goes sideways ends up being a big blip instead of a tiny blip. It also increases the potential that that homeowner is going to become a raving fan of yours and refer you to the next person, to the next person, to the next person. So I know that this is not legal, but it becomes legal, and I see it become legal all the time. Avoid the crazies, build the relationships, and included in building the relationships, recognize that your subcontractors to the owners are you. They are, not legally. Legally, they're independent contractors, and we'll be talking about contracts in a second. But from the owner's perspective, if you're a general contractor, they hired you, and you're bringing in these other people. And if these other people are misbehaving on the job, leaving a mess, swearing, really loud music, doing things that you wouldn't do yourself, understand the response to the owner can't really ever be, that bad subcontractor, he's just a bad guy. That's you. You're going to have to own it, and you're going to have to correct it. But build your team so that you don't have to face those issues, and make sure your subcontractor team understands that they need to behave in a certain way. We've for some of our clients, they've got sort of a code of conduct that they have that they expect subcontractors to follow, and we've put those into their subcontracts. So give that some consideration as well. Another leading cause of litigation, and the reason I keep focusing in these two slides on the dangers of litigation is not even necessarily because you've done something wrong, but because once you get pulled into litigation, once you get pulled into needing the lawyer to help you resolve issues, you're spending thousands and thousands of dollars on that time and materials contract you have with your lawyer. And all of that's hitting your bottom line. And I can almost guarantee you that when you entered into whatever contract it is that gives rise to this need for a lawyer, you didn't build that into your costs for the project. So it's directly wiping out your bottom line. All right, so the second touchy-feely issue that leads to litigation is ambiguity. Ambiguity in the communications. The first way that you can minimize the ambiguity is not only by having a written contract, but writing it clearly. Now, we'll be talking about different types of contracts in a moment, but you should have a contract with every other party that you're dealing with on a project. So if you're a general contractor, you're going to have the general contract. You also need to have subcontracts. And at minimum, maybe that subcontract is in fact a purchase order that's signed by both the parties. But the more you have in writing, the less chance you have for problems later on. Again, litigation most often doesn't come because one party's the absolute good guy and one party's the absolute bad guy. It comes because of bad relationships, but what most often fuels the bad relationship is that mistrust, and that mistrust is often fostered by ambiguity in what the parties agreed to. That is, if you don't put it in writing, you're not going to remember clearly whatever the it is that you agreed to a week or 2 weeks or a month or 2 months or 6 months down the road. I honestly, I can't remember what I had for breakfast 2 days ago. You guys have multiple projects going on. You're not going to remember certain key things. And importantly, neither is the other party that you're making an agreement with. So if you're going to have an agreement, it needs to be in writing. That written contract should explain all of the rights and responsibilities between the parties. Everything that you leave out increases the chance for ambiguity later on. That is a misunderstanding as to what the rights and the obligations are. A really important area of your contracts is the actual work description. That is, contracts are filled with a lot of legal mumbo jumbo, and we'll be talking about different facets of that legal mumbo jumbo today. But there is a section in all of your contracts, or there should be, that describes what's actually going to be done. What is the work, or what are the services, or what are the materials, or the equipment? I see a lot of times that there's ambiguity in that section. And it happens not because of any intent. It happens because contractors negotiating with owners or negotiating with subcontractors or vendors, you guys know exactly what it is you're talking about. And so does the other side, at least you think they do. And when you go to write up the work section of the contract, a lot of times you write it up in the context of, I know what this means. The other side knows what it means. We're good. That's not the right way to do it. Because if there's a problem down the road on what you contracted to receive in the work section or services section, you're not going to decide what it means. The other side's not going to decide what it means. A third party is going to decide what it means. You know, an arbitrator or a judge or a jury, a mediator may look at it, and they're not going to have the benefits that you have necessarily of being a construction expert. And so stay away from, you know, shorthand construction lingo. What I often suggest to clients is, when you write this section, take a step back and then come back and look at it and think to yourself, would my spouse understand what this means? Because if your spouse wouldn't understand it, then probably your average third party, your average jury person or a judge or an arbitrator isn't going to understand it either. And that's what's important. You need to understand it. The other side needs to understand it, but it needs to be written so that if there's any confusion at all, a third party who has no expertise in your area would understand it. Another important piece to avoid ambiguity in contracts is that there be what's called a merger provision, or sometimes it's called an integration clause. And that's the legal mumbo jumbo you see in contracts that says this is the party's complete contract. And the parties recognize and agree that they're not relying upon any prior communications or correspondence, and that everything that is part of their agreement is contained in this agreement. That should be in your contracts so that it is clear when you sign off on the bottom line of whatever the contract is, and the other side signs off on the bottom line of whatever the contract is, that's your deal. Your deal is in the four corners of that document. And that's not to say that the document can't, expressly incorporate other documents, but it should be clear, this is our complete agreement. This is it. One more word about the work section and ambiguities that arise. I represent subcontractors, I represent some vendors, and I represent general contractors too. But I'll talk about this from the general contractor's perspective now, because it's a good example. What I see a lot of times is general contractor in the work section of the subcontract says, instead of writing out a description, we'll say something like, see purchase order from ABC subcontractor. And it could be argued then that that whole purchase order is now incorporated into the subcontract. That may not be a problem. You know, maybe the terms are written clearly in the purchase order as to what's going to be done. But 9 times out of 10, the purchase order also has legal conditions that are part of it. And so if you just incorporate the purchase order into your subcontract via this work section or services section, you'll oftentimes be incorporating in legal terms that are inconsistent with other legal terms in your subcontract. And maybe that your lawyer, you spent money on your lawyer creating, and now you've arguably just negated them. And at minimum, you've created a ton of ambiguity into what your subcontract really is, because you've got conflicting terms based on the the original terms in your subcontract versus the legal terms that have now been incorporated in by the purchase order. So if you're going to make reference to the purchase order in the work or services section of the subcontract, you need to say the work identified in the purchase order, XYZ purchase order, is hereby incorporated, but no other terms from that document are being incorporated. You need it to be clear that we're only putting in a piece and not everything else that comes with that purchase order. If you do that, you should be okay. Ambiguity, or the potential for ambiguity, continues even after you've signed the contract. That is, things come up on jobs, changes, orders to do additional work, requests to do additional work. And a lot of times things don't get documented well in terms of what the change is, whether there's going to be change order monies paid, whether there's additional time that's going to come from the additional work or the changed work. It's really important that you document these things. We're going to be talking about claims process in a few minutes in contracts, but I'm going to talk about that a little bit right now too. Most of us have these cell phones. In fact, probably 99% of our population has these cell phones. When I first started handling construction cases, there were a lot of times there were issues about whether there was an agreement, whether there was agreement or approval to do certain change order work. And subcontractor would be saying there was, general contractor would be saying there wasn't, and where's your change order? And sub would be saying, I don't have a change order. You told me to get it done. I didn't have time to go back to the office, type up the change order, fax it over to you, get it signed off on. It was going to slow the job down. Still wasn't good practice. It wasn't the way to do it. You should always have some sort of written confirmation. But especially in today's world with these, how many emails a day do you send? How many texts do you send? I know I deal with hundreds of emails and texts every day. I'm sending messages all the time. Imagine you're at a deposition and you say, we had this big change order, and the lawyer for the other side saying, well, where is it? Well, I didn't get anything in writing. It was, they told me to do it, and it needed to get done, or I needed to get started on it that day, or we were going to lose time. And lawyer says, well, you got a cell phone, don't you? Yeah, I got a cell phone. How long have you had a cell phone? I don't know, 10, 15 years, however long. Do you email? Yes. Do you text? Yes. How many? I don't know. Maybe 100 a day. 100 a day. And does your phone have one of those microphone functions on it where you can even just talk into your phone? Yep. And how long would you say it would take to send to create a text or an email using that microphone function to say 2 sentences? I don't know, maybe 10, 15, 20 seconds. But you're telling me that on this $100,000 change order issue, you couldn't pull out your cell phone and hit the microphone and send the message? And you look a little bit like a fool. And the lawyer's done it to you, but you've created the issue yourself by not documenting. And so even as projects are going on, if there are changes, if anything of any significance is coming up on that job, you should be emailing to the other side. Now, I'm not saying don't have verbal communications. You should. But once those verbal communications are done, you could see, somebody told you, instead of having 3 hi-hat lights in the ceiling in the basement, they want more light. And so they're telling you to put in 5 of them. They want you to do some different kinds of lighting and move it around. And you've reached an agreement based on your verbal. Well, now you step back, you actually say to the person, great, I'm going to send you an email right now or a text confirming it. I prefer email, but I'm going to send you an email right now confirming this. Take a look at it. If you agree, just send me back an email and reply saying confirmed. That can be your change order, and that can document changes that protect you going forward. The lack of written, clear communications is one of the leading causes for problems down the road. One of the things you hear probably quite often is most cases settle. That's true. Most cases do settle, but they settle along the lines of who has more leverage. And so if you make changes on the job and you're not documenting them and getting confirmation or agreement from the other side while you're doing that, you are giving the other side leverage in the event of a future disagreement about whatever the change conditions are and how much money is due or time. Excuse me. You are giving them leverage to say, look, our contract requires that all changes be in writing. Where's the writing? It's not there. You have waived your right. There is some case law out there that says if there's a written process for making claims and documenting changes, and if it's not followed, there's some case law out there that says you've waived your claims. Now there's some defenses to that, but think about what I'm talking about. You've just given the other side leverage to say you've waived your claim. I've told you there's some defenses to that, but you're gonna have to hire a lawyer to create those defenses. The lawyer's gonna have to spend a lot of time mastering the facts to create those defenses. All of that on a time and materials contract. All of it is slamming your bottom line such that it's gonna lead you to make a business decision more often than not, which is, I'm gonna take a haircut on this. I'm gonna take a significant haircut because fighting it is going to be worse. So I may be entitled to $50,000 or $25,000, heck, $10,000, whatever it is, but I didn't document it well. And now it's going to cause me X dollars to fix it in a fight. I'm better off taking a big haircut and moving on. So avoid those situations. Avoid giving the other side leverage. Document, document, document. And especially where it only takes a few seconds with your cell phones to do it. All right, when you think about contracts, there's so many different kinds. I'm not going to talk about all of these today. In fact, I'll be talking about pieces of these different contracts today. Joint ventures, I don't think you guys are probably getting into joint ventures, although on larger multifamily things, I guess you could. Joint ventures were popular during the big dig. A lot of the big commercial contractors had joint ventures going on. I don't think that's normally something you're going to have to concern yourself with. What you're seeing are general contracts, if you're a general contractor, obviously. And in your business, if you're, unless it's multifamily work, most often it's going to involve, or oftentimes it's going to involve the home improvement contractor statute, which applies to work on primary residences where there are not three or more than three residential units within a building, as long as it's a primary residence. So home improvement work, primary residence, additions and remodeling, other than in buildings that have more than three other units. To that end, I circulated to Scott, and I know Bragby has sent it out, an article that we drafted quite some time ago entitled, Did You Know? And it reviews some of the highlights of the home improvement contractor statute and things that you need in your contracts. Now, I said we drafted it quite a long time ago. It's true. The statute hasn't really changed. And so it's one of those things you really should be, if you're doing work that is subject to the home improvement contractor statute, you really need to spend some time making sure that you are complying with the home improvement contractor statute. Because if you don't, and you have any sort of disagreement with the owner about payment down the road, or maybe it is one of those instances where the owner's wearing the black hat, just not a good person. If they go to a lawyer and the lawyer is worth their salt, they're going to go, the first thing they're going to do is go to the home improvement contractor statute, pull out a copy of your contract, compare these things, compare your contract to see whether it has compliance with the statute. And if it doesn't, they're going to try to work with their client to create an argument as to how your non-compliance with the statute has caused their client damages such that your violation of Chapter 142A, the Home Improvement Contractor Statute, becomes a violation of the Consumer Protection Statute, which you should care about because it makes you potentially liable for attorney's fees and double or triple damages. Not only that, if you are the one with the license under the Home Improvement Contractor Statute, pursuant to which the work is being done, there's personal liability for the license holder. So Home Improvement Contractor Statute is one of those things that you may not like it, but it is part of the risk management business. You've got to get in line with it. You've got to spend some time with your lawyer, making sure that your contract is compliant. If you don't, you give the owner leverage to knock money off your bottom line by shaving money off your final payments, by threatening you with letters from their lawyer about not complying with the statute. I know it doesn't sound pretty, but it's what happens. Subcontracts. Obviously, if you're a general, you should be creating subcontracts with your subcontractors. Even subcontractors, though, you may have subs and vendors that you need to deal with, and you should have written agreements. Now, if you are a general contractor, there's some different forms of subcontracts that we've worked on with our clients. One is, if you've built up a really good stable of subs that you work with again and again and again, rather than having them sign some lengthy subcontract every project, what a lot of our clients like doing is having a master subcontract agreement that gets signed one time, and then they'll have a 1 or 2 page document entitled subcontract that gets used for each project. That 1 or 2 page document incorporates the master agreement, which is longer, and it contains a whole lot more of the rights and the obligations. But in that way, you can have light paper job to job. You just get the master agreement signed once. For those subs that you don't work with often, or maybe it's just, especially if it's a smaller job, you can, and we have created what we call small job subcontracts that make it easier to get signed, because maybe you've had that experience where you've got this great subcontract that's really long, but you're hiring a sub on a job that's only a couple $1,000, and that sub just is not going to spend time looking at a 10-page master agreement or anything like that. It's not worth it to them. So you can craft a smaller job subcontract that you can use for those smaller subs. You should also take a look if you're doing any design work such that you're going to need a design professional involved. You're going to need to be careful about creating a good contract with your design professional that manages your risk through them. That is, to the extent that you're taking on any design responsibility as part of your contracting responsibilities, but you're actually bringing in a design professional as a subcontractor, you should be passing through the design risk to that design professional. Last, purchase orders. Typically, I see those being used with material suppliers, with vendors. Same thing. You need to with your purchase orders, they're not going to be as long as a general contract. They're not going to be as long as a master agreement, for a subcontractor. But you can still put together a good risk management page to go with whatever your main page as to what you're purchasing, such that you should be able to have a 1 or 2 page purchase order that manages your risk as well. All right. So let's jump into some key risk points. One is avoid assuming design risk unless you're doing it with intent. That is, if you know, yes, I am a design builder on this job, okay, that's nothing wrong with that. That can work out quite well. In that instance, again, if you're subbing the design piece, you need to have a really good design subcontract in place. You also need to have the right insurance in place. If you're contracting to be a design builder, you not only need to have a commercial general liability policy, you need to have an insurance policy that protects you from design risk and errors and omissions policy. It's a materially different product. It's, you know, insurance policies aren't widgets to begin with. They all vary a little, or they potentially can vary. But separate from, you know, even commercial general liability policies that can be different one to the next, a errors and omissions policy is a materially different product and ensures different things than a commercial general liability policy. And it's one you'll need to speak with your agent about having if you're doing design work. And there's a cost for that. So you need to make sure that that's carried over in your contract. But in most instances, you're not design building. And because you're not design building, you need to be really, really careful about not taking on that design risk. Again, you may not be insured for it. You probably aren't. If you're not normally doing design work, you probably don't have that insurance. So if you're unwittingly taking on design responsibility, you're doing it without having an insurance safety net because you don't have that errors and omissions policy. So don't take it on for that reason. Second, you're not getting paid for it. You're not getting paid to do the design, and there's a lot of cost that goes into doing it. So we got to be really careful about not taking on design risk. You're not getting paid for it, you don't have insurance for it, and you're creating a huge risk for yourself. I want you to look at this provision, which I created a slide out of, but it actually comes from a contract I was negotiating for a contractor years ago. And it has some language in it that purported or wanted to shift the design risk over to my client. We took it out. Namely, it's that bolded language at the end. So this was from a bastardized AIA, I think 201 contract, general conditions for contract for AIA. And there is a provision in the AIA that looks a lot like this. It requires the contractor to carefully study the documents. Basically, it wants to be sure the contractor is doing its due diligence, looking at the documents, going out to the site, maybe saying to the contractor, you know, you've got a duty to inform the owner or the architect of any discrepancies you find. All of that's fair. All of that, frankly, if you're entering into a partnership relationship with the owner can properly expect of you, and you probably expect of yourself, and it'll minimize the chance for problems going forward. You want to do your due diligence. Where the problem comes up is the way that they modified the language. In the standard AIA, without modifications, it says that it's recognized that the contractor's review of the documents and making a visit to the site is done in its capacity as a contractor and not as a design professional. And its only duty is to identify discrepancies that it actually discovers. But here's where things go wrong in this modified version that the owner tried to foist upon my client. Down here 4 lines up from the bottom, it says, having discovered such errors, so if the contractor has found mistakes in either, based on a review of the documents or having gone out to the site, having discovered such errors, inconsistencies, or omissions, or if by reasonable study of the contract documents, the contractor should have discovered such, the contractor shall bear all costs arising therefrom. That's terrible. If by reasonable study of the contract documents, the contractor should have discovered. So what I can predict would have happened on this project had we not stricken that language is, that is, had my client accepted this, when it went to the owner for a change order in the future because something in the design didn't work, the owner would have said, well, wait a second. You were supposed to have done due diligence on the design, and your client, the contractor, saying, I did due diligence. Well, wait a second, but the language says, if by reasonable study of those contract documents, you should have discovered the discrepancy, then you own the cost. And I think, you should have been able to discover the discrepancy, the omission, the problem that you're now complaining about and saying you need a change order for. I think you should have been able to discover it. In that instance, the contractor is going to probably be fronting the cost on every change order issue that comes up, or most of them. And it's going to have to reserve its rights, do the work, and fight about it later. But now it's bankrolling all, so much of the change order work. It's not fair. Some contractors would go out of business if they had this sort of situation. But the fact is that if you allow this to exist in your contract, you bargained for it. So the moral of this story is not all contracts are the same, and you got to carefully look at them to make sure that you're not taking on the kind of risk that you shouldn't be taking on. In this instance, design risk, because you're not getting paid for it, you don't have insurance for it, and you're creating a huge risk for yourself, including but not limited to not being able to get change orders down the road that are caused by things like design that are not your problem, but now you own it because you've agreed to a provision like this. Another risk point, and this is whenever you are subcontracting. So whether you're a general or whether you're a subbing to a sub-sub, you want to make sure you're passing through the risk. And the reason is you're not doing that work. So in a general contract, maybe the general contractor is still doing some of the carpentry and miscellaneous stuff. But on other jobs, the general contractor is really a construction manager and not doing anything. In any event, when the general is subbing out plumbing work and HVAC work and electrical work, the general should be passing through the risk for each one of those items to the subcontractor. And the way you do that is through incorporation language in the contract, in your subcontract, that says words to the effect of, this subcontract incorporates the general contract, including all of its including all the documents incorporated into the general contract to the extent it pertains to the subcontractor's work, including any general conditions in the general contract. So that's how you do it. Again, the why you do it is because you're not doing that work. And so you should be passing on the risk to the party, or responsibility to the party that is doing the work. And you do it by just dropping it into your subcontract. Now, the response you might get from a subcontractor that's doing its due diligence is, okay, I get it, I get the point, but I haven't seen your general contract. Before I agree to have all of your general contract terms and conditions related to my work dropped into the subcontract, I need to see what that looks like. That's a legitimate ask. And in fact, if you're a general or you're a sub talking to a sub-sub and they're making the ask, you can't very well say no. Otherwise, you can't properly incorporate the contract with the tier above you. And if you're worried about the tier below you seeing the financial conditions, you can white that out, redact out whatever the financial terms are, and give them the rest of the agreement. Indemnification. This is something that any subcontract or sub-subcontract worth its salt should have in it. It's a fancy word. Really what it means is the tier below you is taking care to defend and protect you from claims arising out of or relating to its work. Pretty standard stuff. With the right indemnification provision, I never say no to it in a contract. That is, I never list it as one of the things that I'm communicating to my client is a reason to just say no to a contract. Again, provided it's the right language. And that's what I want to talk about right now. Not all indemnification provisions are the same. There's nothing wrong with taking on indemnity. It's in the marketplace. If you have a policy that just says no to all indemnity, you're probably not going to get a lot of jobs. But the indemnification should be tied to your insurance. In fact, that's the way the AIA does it. The American Institute of Architects form contracts. They have their indemnity tied to insurance. So if you're getting pressed by the party above you when you start to give maybe some of the comments that I'm going to share with you now, when you're faced with a unfavorable indemnification provision, if they're giving you a hard time, say, hey, no, this is not fair. In fact, it's not even standard in the marketplace. Take a look at the American Institute of Architects contracts that are used all over the place. They're the prevailing contract, and they don't have the unfair language that you're trying to foist upon me. All right, so that's enough of my blah, blah. Let me walk you through these next couple slides to identify and make sure that you understand what's okay and what's not okay in an indemnification provision. The first slide is that we're going to look at here, or that you're looking at right now, is definitely not acceptable. It's not acceptable because it is much broader than what can be insured. And so think about this. What is insurable is under a commercial general liability policy is negligently caused, so negligently caused personal injury and property damage. That's what you should be accepting indemnification for. Negligently caused personal injury and property damage. If it's more than that, it threatens to be uninsured, meaning if there is a claim that comes up later and the tier above you comes to you and says, you have to indemnify me, here's what the provision says, and you pass it on to your insurance company may very well say, sorry, this isn't something we cover. So let's look at this slide now and identify exactly what it is we don't like about it. Contractor agrees to indemnify, defend, and hold harmless the owner's reps, including the architect and engineer. All right, let's stop there. Remember, I talked a few minutes ago about the fact that if you're doing design work, you need to have a different type of insurance. You need to have an errors and omissions policy, design professionals policy. That's because the claims against architects and that's because claims against design professionals are of a different sort, a type that's not covered under your commercial general liability policy. Okay, so that brings me back to the slide here. You'd be agreeing to indemnify, defend, and hold harmless the architect and the engineer. Well, the problem with that is, as it's written, that could be for any type of claim arising out of your work. Most of what the architect and the engineer are doing are design related. So there's a very good chance that the claims that are against the architect and the engineer could derive from alleged design negligence. Why is that important? Well, under this provision, you've agreed that if a lawsuit gets filed and it includes claims against the architect and the engineer, even if they're design related, if they arise out of your work, you have to indemnify, defend, and hold them harmless. So in that instance, you could have the architect and the engineer sending you a demand for indemnity. You flip it over to your insurer, and your insurer says, sorry, these are design professional claims. We don't cover them. So that would mean now it's coming out of your pocket. And if you're not indemnifying, defending, and holding them harmless out of your pocket, you're in breach of contract. So that's the first problem we have with this provision.
Excuse me, Mike.
Yeah.
A question from Daniel Harvey. Would incorporating with a sub be concluded in a master contract?
Incorporating. Yes. Yes, you could have it in the master subcontract. I'm trying to think about how we do it, where we have that language, whether it's in our master agreement or whether, just to be sure that there's no ambiguity, we put it in the one pager itself. But yes, whether it's in the one pager or in the master agreement, the incorporation clause needs to be in one of those two places. I'm happy to take a look later and have a follow-up on that. Back to the indemnity. The second reason this provision stinks is it doesn't limit the indemnity, defend, and hold harmless obligation to personal injury or property damage. We see that here because it says you have to indemnify, defend, and hold harmless from any and all claims and damages arising from, related to, or caused by contractor's work. Any and all, so anything. So to recap, we don't like it because it requires you to indemnify design professionals in a manner that is outside of the CGL policy, and because it requires you to defend, indemnify, and hold harmless for any and all claims and damages, not just negligently caused personal injury and property damage. All right. So that one, if I was looking at that provision in a contract, I would modify it. Here is a provision that is acceptable. We're going to look at one right after this that is even better. This one is acceptable though. And it's acceptable because it doesn't have the two problems that we just looked at. In this one, it says, in those first lines, it says the contractor is going to indemnify, defend, and hold harmless the owner. Nothing about design professionals. Okay, so that's good. And then going forward, or going down in the slide, it says that you're going to be indemnifying, defending, and holding harmless the owner from damages, losses, claims, etc. And then here's the important phrase: arising out of or resulting from performance of the work, provided that such claim, damage, loss, or expense is attributable to bodily injury, sickness, disease, or death. All of those are bodily injury for purposes of a commercial general liability policy, or for the injury to or destruction of tangible property. So there's no problem, no problem with architects and engineers being named. So you don't have the potential for design related claims that aren't covered under a CGL policy. And it's limited to personal injury and property damage. Now, one word about that, because sometimes my clients, when I get a provision like this, I'll tailor it so that it's tied to the insurance. We'll get rid of the architect or the engineer, we'll send it back, and the client will get pushback. Not always, but sometimes. And in that instance, what we'll say is, okay, we'll agree to indemnify, defend, and hold harmless the design professional, but only to the extent that it's covered under our commercial general liability policy. If you put that in, you can live with it as well.
Another question for you, Mike.
Yep.
This is from down the mall. Is it considered a bad faith act if a customer is working with two contractors at the same time and cancel with one right after a permit is filed? If it is a bad faith act, can you charge damages for that bad act?
I'd need to know a little bit more to know if it's a bad faith act, but it sounds like it would be a breach of contract for which the owner could be liable. The issue would be whether there's a termination for convenience provision that allows the owner sort of an escape hatch from the contract. It's one of the things I'm going to deal with momentarily. And we'll conclude on that point by saying you should not allow there to be a termination for convenience provision in the contract. But if there is no termination for convenience provision, and the owner, as I understand this question, simply terminated one contractor because he decided that he liked working with the other contractor, probably because of a pricing issue, despite having signed a valid enforceable contract with the first contractor, then it's probably a breach of contract. And the measure of damages would be not only the work that you've done, but your lost profits on work that you haven't done. Again, that can be modified by contract, so I'd have to look at what the contract says, but that would probably, that would generally speaking be the way to deal with it. It'd be a breach of contract claim for what we've done and our lost profits on the work that we were precluded from having the opportunity to do. Back to the last slide on indemnification. This is the best of the last two. The previous one I said was okay. This one is even better. It's essentially the same as the last one, but the last clause here is better. it requires that the contractor indemnify and defend and hold harmless only to the extent caused in whole or in part by contractor. What that means is your defense indemnification and hold harmless obligation is limited to your percentage of fault. So in the last one, the last slide we looked at, it was all covered by your insurance, but any claim that arose out of your work that related to personal injury or property damage would require you to provide full indemnification, even if the party you're indemnifying was itself partially responsible. Here, in this one, you only have to indemnify, defend, and hold harmless to the extent caused in whole or in part by you. Now, that's the best case indemnification provision. But if I got either of those the last two that we walked through, I would say, and you know, assuming the rest of the contract worked for my client, I'd be fine with either of those. Additional insurance is another risk point that you should be aware of and that you should be doing your due diligence on. The tiers that are working below you should not only be under written contract with you, should not only have to indemnify, defend, and hold you harmless, should not only be owning by way of the incorporation clause we talked about earlier, the rights, owning responsibilities rather, and risks for the work that they're doing such that you're passing it through to them. But they should be taking on the responsibility to add you as an insured to their commercial general liability policy. That's additional insured. That's what it means. You have been added as an insured to their policy. The way to do that is with language in your contract that requires it, and then the way to make sure it's happening is to get the insurance certificate from your sub, and in the bottom section of that certificate of insurance, it should show you not as a certificate holder, but as an additional insured. Now, if you really want to do your due diligence, you should ask your sub to get you their policy so you can actually see that you've been made an additional insured by the insurer, because certificates of insurance are not, they're not 100% perfect. In any event, most of the time what I see from the due diligence end is at least get the certificate of insurance. Frankly, you shouldn't let subs that are required to make you additional insureds onto your project without having that certificate of insurance. It's not a hard thing to do. For your subcontractor, you know, that is, to the extent your sub saying, you're making this too hard on me, it's not. If your sub is saying that to you, they just don't understand, or they don't have a good insurance agent. Because what they should be able to do is flip the subcontract insurance section over to their insurance agent and say to their insurance agent, look, you know, I'm not an insurance professional. One, confirm I've got all the coverage. Two, I need to give a certificate of insurance to the general contractor. And three, I know I need to add him as an additional insured. Get me an insurance certificate that shows that. The insurance agent should be able to readily do that you know, if it's really under the gun, they should be able to do it right then. But in any event, they should be able to turn that around within 24 hours or 48 hours. It shouldn't be a problem at all. What that gives you is, in the event of a future lawsuit, you get sued, you know, it's personal injury or property damage such that your insurance carrier potentially owes you coverage. You're obviously, if you get sued, you're going to flip it to your agent. Your agent's going to turn it over to your insurance carrier. Where you're an additional insured, you should also be sending that lawsuit to the insurance that you've been added as an additional insured on, with a letter that says, hey, I'm enclosing this. I'm also enclosing the insurance certificate that confirms I'm an additional insured on the policy, and I'm demanding coverage. So that you've just now added insurance protection for yourself on the job. And if your subcontract is written the right way, it'll provide that the subcontractor's insurance is primary to your insurance, such that your insurance sort of becomes more of the excess insurance. The only reason that you care about that is the less your insurance gets impacted over a long period of time, the better your rates can be. So it's another form of risk that you're passing through to your subcontractors through the subcontract, namely making sure that you're added as an additional insured on their policy. So this is a new slide for me, and I got it because when our program materials went out, I quickly heard from an insurance friend of mine who is near and dear to a lot of your hearts, Tom Messier. He said, Mike, you're not dealing with risk of materials on the site and work in progress. How can you be talking about risk management and not dealing with that? And I said, Tom, you're right. We now have a top 14, not a top 13 program, courtesy of Tom Messier. So thank you, Tom. In your subcontracts, you should be dealing, one of the issues you should be dealing with, and one of the issues you should be dealing with is who owns the risk of the work and the materials that are on site before the work gets completed. The reason that's important is what happens if there's a fire or there's a flood or something else, a hurricane, a tornado comes through, something destroys the work or your materials go missing. Who's responsible? Your contract should identify who's responsible. There's a really good argument that if it's not identified in the contract, you're responsible. So if you've got some other understanding of that, you need to make sure that it's in your contract. One of the ways to deal with the risk, of course, is insurance. And so, you know, this may not come up on a small, you know, on a bathroom, a smaller bathroom project, maybe even on a smaller kitchen project, but on any, you know, frankly, you should just have it, this in your form general contract, and that is that as decided between you, contractor, and owner, who is going to be insuring the work in progress. Once that is dealt with, if it is, there should be some language that is specifying exactly, you know, what is being provided, a builder's risk policy, some other insurance product, but you can talk with your agent about the best way to make sure that there is a policy in place that protects the work in progress from, you know, from events that would otherwise wipe it out. And then you have to, of course, if, you know, if you're going to be the one dealing with getting the insurance policy in place, you need to know, because you need to factor that cost into your contract. Likewise, the owner may need to take steps to deal with it, but you need to make sure that the project is insured while the work is going on. If the owner is picking up the insurance, you want to make sure that the language in your contract requires that you and probably your subcontractors are additional insureds on the policy, so that if there's a loss, you're covered. Warranties. Warranties are a fancy way of saying promise or guarantee. So simply saying we warranty by itself, just the word, doesn't really convey a lot. It's I guarantee, I promise. The question is, of course, what are you guaranteeing? What are you promising? And for how long? So in your contracts, you need to deal with that. There's some minimum things that you should have in your warranty language. Specifically, what is it that you're warrantying? Are you warrantying the labor? Are you warrantying the materials? Are you warrantying equipment? Or are the materials or equipment going to be turned over? Or are they going to be warranted through a manufacturer's warranty? You need to think these things through and make sure you're clear what it is exactly you're warrantying. Likewise, you need to identify exclusions that may fall within that warranty. So, you know, a good example is you warranty your workmanship to be free from material defect. And I use that word material. I like to throw in the word material defect, because if you just say free from all defects, it sounds good. And as great a work as you do, you could still have claims. And that is because owners may have a different view. You may say, no, this is beautiful. This is perfect. And the owner says, no, I think it's not quite right. you should have in there, it is free from material defect. But even with that, you want to identify perhaps, things that should be excluded. So, I was going to say a good for instance is you've got this warranty of that there's no material defects, but then you've put in a concrete slab in the garage, and or maybe in somebody's in the basement, but there are little fissure cracks that develop. Now, I'm obviously I'm not a contractor, but I hear from my clients all the time, well, a certain amount of fissuring, a certain amount of these lines is to be anticipated. It's natural. It's not a defect. And so that's an example then of something you'd want to put into the contract is excluded from warranty. You'd also want to put into the contract that normal wear and tear is excluded from warranty. So take a look at take a look at the work that you're doing and think about the naturally occurring things that come up, even in a well-done project. And you may want to identify those as exclusions from the warranty so that nobody's hitting you with it later. How long is the warranty going to be? I see standard, it's 1 year, but I've got clients that are warranting their work out 2 to 3 years. So think about how long you want it to be. You need it to be in there. Otherwise, it's going to be, maybe it's argued that it goes on for, I don't know how long. You want to put in how long your warranty lasts for. You also need to put in the process by which warranty claims get made. Otherwise, you could find a situation where, the owner thinks something goes wrong, owner takes care of it, herself or himself, and then sends you the bill. And you're saying, well, what's this? Well, you warranted your work and X, Y, and Z went wrong, and I took care of it because you were in breach of your warranty. And you're saying, well, wait a second, you needed to notify me. You needed to give me an opportunity to fix it. Maybe depending on some other language in your contract, but arguably not. So put into your contract the process by which they have to make a claim. It should be, that it's in writing. That can be by email too. You should identify who it's going to, who they need to notify. And importantly, you need to put in there an amount of time within which they have to notify you after becoming aware of whatever the alleged defect or alleged failure is. Otherwise, you could have a situation where an owner recognizes something, sits on it for a matter of months and months, and maybe it becomes a bigger problem. And then they notify you. And instead of having the opportunity to identify and deal with a simple issue, it's now become a bigger issue. And lastly, provide for what happens when they don't follow the warranty process. Usually what we have in our contracts, if they don't follow the warranty process, they waive their claims. All right, I talked a little bit about this earlier, but I really want to focus on it. Comply with the contract claims process. There's a couple reasons for claims process, and I'm going to include change order process within claims process here. There's a fair reason for it. There's an unfair reason for it. The fair reason for a contractual claims process is so that the tier above you, whether it's a sub or a general or an owner, is always aware of claims. And why might they want to be aware? Well, they may have an obligation to pass up that claim to a tier above them within a certain period of time. And for an owner, the owner should be aware of claims that are out there and the amount of money that it has potential exposure to paying, because it can affect other change order decisions the owner wants to make. You can envision a situation where an owner gets hammered with a bunch of claims at the end of a project that it wasn't aware of. And the owner says, well, wait a second. Had you told me about these earlier on, I might have made a decision not to have you do that extra square footage that we put onto this because of the exposure I already had. So that's a fair reason. So that people can make good decisions about what they're doing on jobs by having more information. What you'll also see is an unfair reason. And the unfair reason comes up when the claims process is unfairly burdensome. So I've seen contracts that require you to make claims, change order claims, for instance, within 24 hours of when you knew or should have known that you had a claim. And you think about that. Why the heck would somebody require you to do it within 24 hours? I think it's for an unfair reason. The unfair reason being they want to have the opportunity to say, nope, you didn't timely notify me, so you don't get the change order. Under the contract, you waived your rights. That's an unfair reason. I think there should be some very, it needs to be timely that a sub or a general needs to make the claim to the tier above it when it becomes aware of the claim. But, whether that's 5 days or 7 days, 21 days, then whatever, that can vary and everybody's got different opinions on that. But there needs to be some fair amount of time for the contractor to become aware of it, to take a look at what effect it's going to have, to think about the cost, and to talk to the tier above it without losing its right to make a claim. So it's important you take a look at this, though, because if you just agree to a claims process that you're never really going to be able to meet, you're unwittingly setting yourself up for problems down the road. Namely, you don't comply with the claims process, you untimely make a claim, and the tier above you says, sorry, you've waived your claim. And that is, again, because the contract, there is case law in Massachusetts that says if you don't follow the claims process that you contracted to follow, you've waived your claim. There's some defenses to that, such as, if you've had, maybe you've had 5 or 6 change orders during the job, you haven't been timely according to the contract in submitting any of those, and the tier above you has allowed you to do it anyways. There's case law out there that says, well, in that instance, the tier above, whether it's the general or the owner, has allowed it to go on in untimely fashion, the claims making process. The party has now been induced to rely upon that course of conduct in calculating in its own mind that it doesn't need to timely make a claim, such that later on, it can be found to be unenforceable, the prohibition about giving the claim because you didn't put it in time. The point is, to get to that point, again, you're gonna hire lawyers, you're gonna be fighting about it, and you're gonna be taking money off your bottom line. You're gonna take money off your bottom line, one, because you don't want to keep paying the lawyers. You're gonna take money off and so you're gonna make a compromise. And you're gonna make a compromise because your lawyer, if you didn't follow the claims process, is likely gonna be telling you there's a decent chance that if we fight this, we're gonna lose anyways, or it's gonna cost us a ton of money to prove it. So don't put yourself in that position. Now, if you're a general contractor and your subs are late getting, a sub is late getting in a claim, I'm not telling you that you need to just hammer the sub. Here's, if it's a sub that you like, you've got a good working relationship with, and you don't want to hurt them, here's what I would say in that instance. Subcontractor, you're late submitting your claim. I'm going to pass it up to the owner. But if the owner rejects it, then I'm going to reject it of you. And I'm going to reject it as being untimely. I'm going to try to get you paid, but if it gets rejected, I am also going to reject it as being untimely. If, by the way, it gets allowed, understand I am not waiving this timeliness requirement in the future. You need to comply with the timeliness requirement, and we won't pass it up the next time. That's the way to deal with it. In that way, you haven't hammered your sub. You've sort of given them a get out of jail free card on that instance. You've put in writing, we're not waiving this provision. And you've told them you've got to comply with it in the future. And then if they screw up in the future, that's on them. That's on them. So that's a sort of a way to deal with this issue without injuring your relationship. Time. As I mentioned earlier, time is one of those critical focuses that an owner has, and it's something the owner can grab hold of in understanding whether, or at least it can point to and say, you're not complying with the contract. You're late. So it's something you got to have real focus on. And you got to have focus on it not only because of the relationship potential, but also because in most contracts, the failure to comply with the time requirements is grounds for terminating you for the job. So in most contracts, you will see this magical phrase that I have in quotes there, time is of the essence. That is the lawyers, it's the legal magic language that courts have found to mean time is a material element of the contract. It's not a minor thing. It is a material element in this contract. And if it's a material element in the contract and you're not meeting your obligation, then it is, under Massachusetts law, grounds for termination. So along the concept of time, some things to think about. One is, how is substantial completion defined? Why do you care about that? Because whether you get done before or after substantial completion is going to be a measure of whether you're timely completing your job. So most of the time, or a good way to define substantial completion is when the owner gets beneficial use of the project. Usually that's at, when the owner's getting at least a temporary certificate of occupancy. But take a look at how substantial completion is defined. Also give some consideration to, from a risk end, if I am committing to this time, what am I at risk of? Well, if you contract to complete the job complete your work by a certain scheduled deadline, and time is of the essence, and you're falling behind on your milestones, contractor a tier above you can terminate you. And so what are the damages then that you're at risk for? Well, you're at risk of the cost that it takes for a replacement contractor to come in and complete your work that are above whatever your contractual balance was. So, if your contract balance was down to $10,000 and you get terminated, and a replacement sub comes in and charges $25,000, well, you're liable for $15,000. And you may say, well, this really wasn't a huge deal to them, to the tier above me. They really, they wanted to bring on their buddy, but the owner had somebody they wanted to be brought on. I've heard of all sorts of Machiavellian schemes, but the bottom line is you put yourself at risk. You put yourself at risk every time you're not meeting the time requirements in the contract. So be really careful in reviewing what those are before you sign on the bottom line that says, you can complete the job. Here's another way that we contractors, I'm putting myself in your boat because I represent so many of you guys, or represent so many contractors. Here's another way that we often fall down. When we get a change order, we don't put on the change order the additional time. We deal with the change order only in terms of cost, but not in terms of time. And a lot of times there's a time component to the change order. Whatever it is going to keep you out in the job longer. It's going to expand the amount of time that you're dealing with. In those instances, or whenever those instances arise that a change order is impacting your time on the job, you need to put that time commitment into the change order so that the time and the money gets signed off at once. In fact, there are a lot of contracts out there that specify exactly that if you're making a claim for time, you have to make it in the same way you make a claim for cost. And so if you don't do it, you're arguably waiving your claim to time. And so you could be taking on additional work and you're getting paid the additional work. That's great. You've got an agreed to change order, but you haven't captured the additional time. Your deadline for completing hasn't moved and you could really screw yourself up later. Last thing to think about with regard to time is who owns the float. I don't see this come up as often on the residential contracts, but I do see it come up a lot on the commercial ones. And certainly the bigger the residential one, the more apt it is to have this sort of issue come up in multifamily jobs, for sure, for those of you who do that kind of work. The float, as you know, is sort of that additional time that's built into your schedule to get things done. So you've agreed to get something done by March 15. In reality, you can get it done by March 1, but you built a couple weeks of float in just to deal with any sort of nonsense that comes up. it is preferable that in your contract you specify who owns that float time. Because if it's not specified, Massachusetts law is unclear on it. And you can get into a whole fight about it. And here's how the fight oftentimes comes up. You know, there's XYZ change order, and you say, okay, well, this XYZ change order is going to need result in me needing an additional week of time. And the tier above you says, well, wait a second. That March 15 date that you committed to be done, we know, we've talked about it. It's got 3 weeks of float in it. You don't need an additional week related to this change order. Well, he just stole a week of your float. He just took away a week of your contingency that you built into your schedule to get stuff done that you were going to use for any sort of nonsense that came up during the job. So who owns the float maybe comes up less for a lot of you, but it is in doing due diligence, it's a good thing to address in your contract. Terminations for convenience. I mentioned this earlier in response to a question that Scott had received. I see these too often. I really dislike them. Terminations for convenience say that the tier above you can terminate you willy-nilly, basically. So without it, let me start with this. Without a termination for convenience clause, you can only be terminated for cause. You can only be terminated if you screw up. You're failing to meet a material term of the agreement. Time is of the essence and you're falling behind on the job. You're breaching the contract in a material way. That can be a termination for cause. That's okay. And that's part of the deal. You sign on to do a contract, you got to meet your obligations. If you're breaching a material term, the other side can terminate you for cause. That's life. But when they add in the termination for convenience, what it means is you can be perfect. You can be, the greatest thing. The owner wakes up on the wrong side of the bed, or the general wakes up on the wrong side of the bed, they can terminate you. And you may say, well, how often do they wake up on the wrong side of the bed? Not often. It's seldom going to be because they decided just to do it willy-nilly. Where I see it come up is owner decides or general decides, I've got another contractor out there that can finish from where we're at for less than I have in the contract balance. That is, I've sort of gotten ahead of the contractor, and there's a $200,000 balance to complete. I think I know this sub or this general that I can bring in to finish for $150, and I'm going to save myself $50,000. That happens. That definitely happens. And if you've got a termination for convenience clause in the contract, they're allowed to do it. So as an initial proposition, I think you should be canceling those. You should write those off. And a good explanation for it is, one, it creates risk for me, but two, if I sign a contract with you, I am devoting a certain amount of my workforce. I'm counting and I'm scheduling to devote a certain amount of my workforce into this block in my schedule. And when I'm doing that, I may not be taking on some other work that I would have otherwise taken on during that block in my schedule. Now, what am I going to do if all of a sudden you terminate me for convenience? I'm left with these people and no place to put them productively, and I'm carrying this cost. And on top of it, if I've lost profit that I had counted on getting from this job, that's not okay. So that's the explanation for why you don't want a termination for convenience. If the tier above you, the owner or the general, is really pushing, then you need to make it at least fair that you're going to have this termination for convenience provision. And the way to do that is to say, as I've indicated in the last 4 sub-bullet points, you put into the contract, into that termination for convenience, that if you're terminated for convenience, you not only get full payment for the work performed to date, you get paid lost profits on work not yet performed. You obviously, you get paid for any material costs you have out there, and they got to pay you to demobilize. Demobilization, maybe yes, maybe no, because you'd have to demobilize if you were on the job, and you're getting your lost profits anyways. But at least you're getting paid for the work performed to date, lost profits, and all the material costs that you have out there. I have even had a situation where I've put into contracts that, and this is sort of a poison pill for the termination for convenience, you also have to pay the cost of a foreman or a superintendent for a month or 2 weeks or something. And the explanation for that again is, look, this is a cost that I am now going to be bearing because I don't really have a productive place to put that person because I had scheduled them for your job site for this month. And now I don't have that because you terminated for convenience. And I don't want to fire them. So I'm going to carry this cost of my super or my foreman. And I may put them on another job, but they're not really that productive. So if you're going to have the right to terminate for convenience, you also have to give me, 2 weeks of what that cost is. All right. Limitations of liability. Some things to think about putting into your contracts to minimize your downside risk. One is, unless you are being contracted to remove hazardous materials and mold, or in the overall contract, the specs identify hazardous material and mold that you're responsible for addressing, you shouldn't take on any liability for that. In fact, it is in dealing with hazardous materials and mold that haven't been identified that you usually see instances of the tier above you having to indemnify you for any damages, costs, delays that you incur as a result of discovering previously unidentified hazardous materials and mold. So you want to deal with that. I would not allow any of my clients, ultimately they make their own decisions, but I would never recommend to any of my clients they enter into contracts where there is not a waiver of consequential damages. Consequential damages are those damages not flowing directly from a breach of contract. So in the instance of a contractor who is slow completing, the owner maybe on a residential project has moved out and they're paying rent somewhere else. In some instances, it could be a situation where the owner had anticipated being able to rent having the construction done and being able to then rent it out. And so the owner is saying, I'm losing rental costs, or I'm paying additional rental costs, or I've got a construction loan that I'm carrying. There can be all sorts of consequential damages, none of which you want to take on. You just don't know. They're too vast and varied for you to ever take on. And what I can tell you is some of those on larger projects and on projects that are more of a commercial nature, for sure, the consequentials can be so big that they would easily wipe out even healthy companies if they were to get hit with them. So you never want to be in a situation of taking on consequential damages. Just say no. And again, mutual waiver of consequential damages is standard in the construction industry. If you have somebody trying to foist it upon you, point them to the AIA. And by the way, if somebody's trying to foist that upon you, go back to one of my first slides here. Don't do business with crazy people. Here's a provision. The third bullet point is something we've worked into a lot of general contracts on the residential side. And sometimes it gets challenged. And were I a homeowner, I would challenge it. But and I'll review it in a second, but I'd say it gets accepted 9 out of 10 times. What it provides is that the contractor's liability is limited to the amount that it is paid, or the amount it is paid on, or the amount of the contract. So it would mean that on a $200,000 job, your maximum exposure is $200,000 to the extent that next bullet point, to the extent not covered by insurance. So that's usually the way it's framed. Contractor's liability on this project shall be no more than the value of the contract to the extent not covered by insurance. Now, again, if I was a homeowner, I'd say, well, wait a second, I'm turning this project over to you. There may or may not be things that are covered by your insurance, but I still, I'm not going to agree to some, limitation based on the value of the contract. In that instance, if it's otherwise a good job, most of my clients tend to, negotiate out this limitation of liability. But again, if you can get it 9 out of 10 times, you've just minimized your exposure significantly. The last bullet point is waivers of subrogation. For those of you who are unaware of the term, subrogation is when an insurance company, typically the way you'd see it is a property insurer, covers a loss for its insured. So a pipe freeze up occurs, there's a burst, water floods the house, causes all sorts of property damage. Homeowner's insurance policy comes in and takes care of it. The homeowner's insurer gets to step into the shoes of the homeowner and file a lawsuit to recover its costs from whoever it believes is responsible. In this case, maybe it would be the plumber for having failed to properly insulate, but it would also be the general contractor. That is subrogation. It's the insurance company stepping into the shoes of its insured. One of the ways to deal with that is to put a waiver of subrogation provision into your general contract with the owner. What you might want to consider, though, for business reasons, is reviewing what that means with the homeowner, because if the homeowner doesn't have the consent of its insurance company to do that, and they waive subrogation rights anyways, they've waived their insurance company's future rights, and the insurance policy may have a provision that says in that instance, the homeowner's insurance is now voided. And so you would have some protection for yourself for sure. But if the homeowner finds out that you've created this scenario without having reviewed what it really means with the homeowner, you could have just created a terrible relationship issue that's going to cost you a lot more than it's worth. So I like the waiver of subrogation provision. Maybe it's because I hate the notion of insurance companies who get paid tons of premium having to step up once in a while and then having the right to go sue somebody. It rubs me the wrong way, but it's their right. So I like to have those in there, minimize the risk to my client. But again, if you're going to have them in there, have the discussion with the homeowner as to what it means, so it does its due, so that your homeowner does his or her due diligence.
Hey, Mike, this is
Yeah.
from one of our fine builder members, Greg Sarkeesian, regarding liability. For a time is of the essence violations. Please describe good examples, if any, are under mass law where a contractor can defend themselves. For example, factors in which they depend for timely work, but which are outside contractors' control, whether it being a basic one, any other reasonable defenses.
Yeah. So the defenses are almost always going to come up in the realm of I was delayed and I was delayed and am entitled to a change order for additional time is going to be the defense. I was supposed to start on January 1, but I wasn't allowed to get out there and start for permit reasons. The town was slow in issuing a permit. I couldn't get out there until January 15. So that pushed my schedule back 2 weeks. That's a 2-week extension that should be argued. But go back to the point I was making earlier. You're going to put yourself in a very bad spot if you don't make the claim for time in the manner that the contract requires. You're going to create an argument for the tier above you, and this, in my example, the owner, to be able to say, well, I disagree with you for whatever reason, but in any event, we don't even have to have the discussion because you waived the right to time because you didn't timely make that claim as part of the contractual process. So what you're going to want to look at in your contract is you're going to want to have in your contract the right to get change orders, including for time, for anything that is outside of your reasonable control. In a nutshell, I mean, there's more precise language, but you're going to want to have in your subcontract or your general contract, if you're the general contractor dealing with an owner, the right to get change orders for any cost or time that are for matters outside of your reasonable control. You'll see things like acts of God. Important language to be thinking about right now is of course the pandemic. Government shutdowns, slowdowns just caused by the pandemic because of lack of workforce. So it's a combination of things to answer the question. One is you want to have good language in your contract that entitles you to change orders for circumstances outside of your control. The other is you need to carefully document when those circumstances are occurring and to make the claims for the additional time so that you're protected. I hope that answers the question. All right, getting paid, which should be nearest and dearest to your heart. You need to specify in the contract, obviously, what type of contract is it? You know, is it stipulated sum, fixed price? Is it a cost plus, you know, sort of a time and materials contract? Is it guaranteed maximum price contract? If it is cost plus or GMP, guaranteed maximum price, what are the costs that you're allowed to bill? That is, if you're going to say it's cost plus or time and materials, you still need to have a provision in your contract that spells out what the costs are that you can pay, that you can bill for. You want to go over what is the payment time frame? How often do you expect to be paid? What are you agreeing to? Is it every 2 weeks? Is it a month? Whatever it is, it needs to be spelled out. In certain instances, you could have the prompt pay law apply. Projects of $3 million or more that are not single family primary residence jobs. So essentially prompt pay can come into play where the home improvement contractor statute might not. In those jobs, there is a limitation on the time for dealing with payment requests and payment being made, both from the owner and from the general and from the sub to its sub-subs. A basic is, you know, general contractor under a prompt pay scenario submits its pay requisition. Owner has 15 days to approve or reject. If it doesn't approve or reject, that rec is deemed admitted due. The owner then has, I believe it's 45 days to make payment, but within that 45 days, it can again reject. It's called the clawback period. In any event, when you add all this time up, from the time that the rec is submitted until the time that it has to be paid, it's about 60 days. There's an additional amount of time that gets added as you go down the chain. And I'm happy to have an offline conversation with any of you who deal with projects that could be subject to the prompt pay law. But in any event, if it's a prompt pay project, you're going to need to deal with it in your contract. Retainage is another item. I see it less on, you know, on remodeling jobs, but it comes up, and you need to take a look at your contracts before you sign off on them, only to find that there's a 10% or a 5% retainage happening. On prompt pay jobs, by the way, it can only be 5%. But I still see on non-prompt pay jobs, I still see 10% retainage being requested at least regularly. And then the way, for those of you who don't often deal with it, retainage, as you know, it's getting held a certain percentage on, from each rec. And then once you reach substantial completion, the way it's supposed to work is retainage all gets released minus the value of the punch list, or, you know, maybe it's 150% or 200% of the punch list. Another thing to think about with respect to the getting paid process is, if you're required to have a schedule of values that you're going to bill pursuant to as part of your work, you're going to want to put in there that the schedule of values is not a metric for quantifying change orders. I've seen it used that way. So, you know, as you know, on the schedule of values, you have many line items of different types of work that are broken out. Apologize. I've seen it where, because there is an ascribed value to a particular piece of work in the schedule of values, that gets used for by an owner for trying to quantify a change order. And it's just not the right way to do it, because schedule of values are really just, they're not a true value of what the individual line items of work may be. Rather, they're an administrative process for assuring that, you know, everybody's comfortable with what's getting paid each month. Really, really important is this last bullet point. you should try to get into your contract the right to recover attorney's fees and costs incurred to collect any amount due. The reason you want that in there is that under our way of handling the law in Massachusetts, but in most every state, you pay your own freight in litigation. So let's say you're suing an owner, you're due $100,000, and the owner's really just messing around with you and been trying to get you to take less. And I can describe for you the way a conversation may go with owner's counsel who would call me. I get the call, I'm talking to owner's counsel, and she says, look, Mike, we may disagree on the facts, we may disagree on the law until the end of time. But one thing we have to agree on is it's going to cost your client tens and tens and tens of thousands of dollars in legal fees to fight this. And your client's never going to collect those fees back. So your client should take a haircut now and get this thing done. Now, I'd come up with different reasons why we think that's not going to be the case. You know, your client's acting in bad faith and yada, yada, yada. But the bottom line is, once I hang up that phone and I call you, I'm going to say, so this is a discussion we had, lawyers emphasizing that not only do they think they have defenses, but you're going to pay a lot in legal fees. We don't have a fees provision in your contract. That is, we don't have a provision in your contract that entitles us to collect the fees that you're paying me to collect what you're due. And the truth is, you're going to pay me tens and tens of thousands of dollars to get this done. So based on the offer that's been put on the table, I know you're due 100, but they're offering you, they're offering you 40. They're really killing you here, but it's going to cost you 50 to fight this. And, there's a 20% chance that they're right. They've got some argument. Now, what I always say to my clients is, if you want to fight this, I'm happy to fight it for you, but I'm leveling with you. It's my job. I got to level with you on what these outcomes can look like so you make an educated decision. And if you're a good business person, after just receiving that advice that I gave you, all right, it's going to cost me 50. So I'm now not going to get my 100. On my best day, I'm going to net 50. And my lawyer's telling me there's a decent chance, it's a 20% chance we might not win this. I'm probably going to value that a little bit. In light of all that, maybe it makes sense from a business perspective that I take 40. And you're angry, but you make the decision. You do it. You make the good business person's decision. You do it. You take 40, but you're really angry. You're really angry about our justice system. You're angry about the lawyers. Maybe there's some truth in all of that. But the bottom line is, it's also your fault, because in your contract, you didn't put a fees provision in. Had you the fees provision in the contract, the conversation could have been flipped a little bit. That is, when I have that conversation with the lawyer on the other side, I say to her, we agree. We disagree on most of this stuff. I get it. But your client is going to pay something on this. And when they pay that something, they're also going to be paying my legal fees at the end. And my legal fees at the end are approaching what this whole thing is worth. Your client has some incentive to get this thing done. And she may not agree with me on the phone. She won't, but she'll call her client. And if she's a good lawyer, she'll have the same conversation that I just relayed that I would have with you. There's a business incentive now. The leverage has been flipped. It doesn't mean that you're necessarily going to get 100%. You're going to get 100 cents on the dollar, but you're in a much, 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 much better negotiating perspective. You've given yourself a lot more leverage. Frankly, you've given your lawyer a lot more leverage to have those conversations, and you've put yourself in a better position to get paid earlier and to get more than you otherwise would have gotten. Last payment issue I want to talk about are mechanics liens. These are the easiest way to put pressure on an owner to get you paid. The problem is, if you don't follow what the statute requires, you miss it by a little bit. If you just screw it up a little bit, you don't have mechanics lien rights. So the mechanics lien right exists under Chapter 254 of our general laws in Massachusetts that create this right. And the right essentially is, if you follow the steps, you have an encumbrance on the owner's property. And you have that encumbrance without having to ask for court permission. You don't have to go into a judge and say, you know, hey, judge, I've got this really great case and I've really been taken advantage of here, and we're certainly going to win this case. And so you should put an attachment on. You don't have to do that. You don't win many of those, by the way. Judges don't like to give attachments. They don't like to have to prejudge a case. They view that as the jury's function at the end of a case. So they rarely give attachments. But with the mechanics lien, you don't need it. You don't need the judge's permission. All you got to do is follow the process. And the process is, one, you got to have a written contract with, you know, the other side. And, you know, it may not be this one document that says contract. I certainly would prefer it. As I said earlier, you should have written contracts for anybody you're doing business with. But if you're in a situation where you're in a bad position, being caused by a bad person on the other side, you're entitled to be paid, and you think, I don't have a contract, talk with your lawyer, because it may be that based on the emails that went back and forth before you started the work, you had offer and acceptance on the material terms. And based on those emails, you can put them, essentially just put them together, and they become your written contract. So you might still have a written contract, but you have to have one in order to put a lien on. It's a prerequisite. Then you've got to record what's known as a notice of contract within 90 days of when work was last performed. It's a form document that identifies your who you contracted with, what, you know, the date of the contract, and depending on whether you're a general or a sub, it may contain some accounting requirements as well. Again, that has to be recorded at the Registry of Deeds within 90 days of when any work under the general contract was last performed. Not warranty work, but any work. If you're the plumber and you finished, and you may think your 90 days have lapsed, but there's, you know, there's still landscaping work going on out there, your clock hasn't even started to tick. It's when the last work, the last real substantive work under the general contract was done. That's when your clock starts to tick. That said, the safest process to control your risk and not miss the deadlines is to think 90 days from when I last did work. All I'm saying to you is, if you screw that up, don't think I've blown this. You may not have. Call your lawyer and talk about it. It's 90 days from when work was last done under the general contract. By that deadline, you have to have recorded notice of contract. If you miss it by a day, you miss it by a second, you don't have a lien. Next, you have to record a statement of account. Again, it's a form document, requires you to set forth accounting. That has to be recorded at the Registry of Deeds within 120 days of when work was last done under the general contract. Now, once you've recorded the statement of account, you're definitely heading down the path towards litigation, because to perfect your lien, you then have to file a complaint within 90 days of when you recorded the statement of account. You then have to take that complaint, a certified copy of it, and record it at the Registry of Deeds within 30 days of its filing. If you meet all those deadlines, then you have a perfected mechanics lien. You have an encumbrance on the owner's property. And that's certainly going to get people's attention, especially in the residential side. In the residential side, one, homeowners, most of them don't have the ability to get a bond and to sort of protect themselves from the lien. They don't know how to do it. They might not have the capacity to do it. They don't have the connections to do it. And so they're now in a situation where they're afraid, somebody just put an encumbrance on my home, I may lose my home. Now, the truth is, in all my years, I've never had to go through a foreclosure process. These things end up doing the trick. But there is that potential, and the homeowner knows it. I've got an encumbrance on my property. Oh my God. Even if they're they're not a fraidy cat homeowner, they still have practicality on their mind. I've got an encumbrance on my property. I wanted to, I wanted to redo my financing, or maybe they want to sell the house. All of those things are going to be prevented because of your encumbrance in the way of a mechanics lien. So it really can create good pressure. Even if you're a subcontractor and you think, well, the owner's not going to pay me. Well, if you're a subcontractor and you slap a lien on the owner it's going to get the owner's attention for sure. And the owner is going to be jumping up and down on the general contractor to resolve this issue. There's one other step that you need to know about if you're a subcontractor or, you know, a vendor to a subcontractor. If you're in that circumstance, so if you're a contractor or supplier, but you don't have a contract directly with the general contractor, then within 30 days of starting your work under your contract with the sub, you have to send what's known as a notice of identification to the general contractor. It's not something that gets recorded at the registry. It's a form document. Your lawyer should be able to put it together for you. It probably has it. It gets sent to the general contractor. And the purpose of it is essentially you're now jumping up and down saying, general contractor, just so you know, I'm here. So when you go to pay the entity that I contracted with, you should make sure that I'm getting paid too. Otherwise, I have lien rights. And in flip side, if you're a general contractor and you receive a notice of identification, there's no need to flip out. It's not recorded at the registry. It's not a sign that the sub between you and the entity that sent you the notice of identification is doing anything wrong, that they're bad. It is just that sub or supplier doing its due diligence as it's required to do under the mechanics lien statute to protect itself in the event it wants to assert a lien down the road. It's giving you this notice of identification so that you can make sure that they're getting paid when you're issuing payment to that sub. Last thing, and this is the last slide, I'm happy to take questions. Just a quick talk about arbitration. Contractors generally hear and think arbitration, I love arbitration, it's much cheaper and it's much faster. There's a little bit of truth and then some downsides. It's cheaper, it's not necessarily a lot cheaper. Arbitration is having an outside service handle your dispute as opposed to the courts. And so AAA, the American Arbitration Association, is one of them. JAMS is another one, but there's individual arbitrators out there who will handle your case. In that instance, the arbitrator essentially becomes the judge and the jury. They make rules, they make rulings on legal issues, they decide the facts, and they ultimately issue decision on your case. Arbitration is like a trial. Sometimes, depending on who your arbitrator is, less formal, but it's held in a private setting, you know, at a business office in a conference room, as opposed to the courtroom. There are certain administrative expenses that come with it, whereas your tax dollars pay for the courthouse and the judge's salary and the court officers and all of that. Your tax dollars aren't paying for an arbitrator. You have to pay for it. So typically it's shared with the opposing party, but that's an additional cost. And the arbitrator's rate is usually, you know, roughly what a lawyer's is. And so it's an additional, potentially significant expense. There's also a filing fee that typically needs to get filed, and it's pretty significant when it's with the American Arbitration Association. So those are some additional costs. It is true that arbitration gets done more quickly than litigation, whereas court cases can take 2 or 3 years, maybe longer now with COVID. Arbitration usually gets done in about 6 months. Maybe it's a year, but usually closer to 6 months. Now, because it's done in a shorter frame of time, there is less lawyer time. So it is cheaper, but it's not cheap. Your lawyer still has to do a lot of work to get ready for arbitration. And instead of that lot of work being spaced out over a couple years, you're now drinking from a fire hose of legal fees in a short period of time. Again, maybe the total is less, but it's not cheap, and it's a lot more within a short period of time. And then you've also got these additional expenses, administrative expenses for paying for your arbitrator. So the truth is it's cheaper. The truth is it's faster. It is significantly faster. It is not necessarily significantly cheaper. Here's a downside to arbitration. If your arbitrator makes a mistake, in almost every instance, you're stuck with it. So if your judge makes a mistake, you can file an appeal with the appeals court. If you don't like the decision of the appeals court, you may have access to the Supreme Judicial Court here in Massachusetts. And hopefully any legal errors get fixed such that you end up having justice done. In arbitration, you're stuck. If your arbitrator screws up on the law, misreads reaches a bad decision on the law related to your contract, just screws it up, you're stuck with it. And the theory on that is, look, you parties contracted to take your case outside of our court system. You have a right to the court system. But once you've contracted to take yourself out of that court system, don't come back looking to us to fix it. Unless there is, you can demonstrate bias, or you can demonstrate that the arbitrator acted outside of his or her authority. You said you agreed to arbitrate A, B, and C, and the arbitrator made a decision not only on A, B, and C, but X, Y, and Z too. Well, that might be grounds for getting a limiting order from the court in terms of the arbitrator's order. But I can tell you, in 26 years, I haven't seen one flipped, not one. I saw one flip temporarily. Famous case, many of you probably heard about it, was the Tom Brady case. And in that case, Tom Brady had been suspended and he'd been fined, and he went through the arbitration process that the NFL provided for, and he lost. So it filed an appeal with the courts in Massachusetts. And what the court said was, wait a second, this was a biased process. And it was a biased process because in that arbitration process, the commissioner, who was the opposing party, got to be the arbitrator too. Well, nothing could be more unfair than that. And so the court found that that one should be flipped. But then it got flipped again, back against Brady. And it got flipped again against Brady because the next court up took a look at it and said, well, yeah, it might have been unfair, but in the NFL's collective bargaining agreement, which the Players Association, of which Tom Brady is a member, signed off on, it provided for this exact process. So you get what you get and you don't get upset. So I took from that a couple things. It was an extraordinary set of circumstances that a court actually found bias. Again, in that instance, the opposing party was acting as the arbitrator. But even in that instance, because it was something that had been contracted for, it got flipped back against Brady. So the long and the short of it is, the downside to arbitration is you may end up with an arbitrator who makes a terrible mistake and you're stuck with it. And just for way of managing your risk, you should be aware of that. It's not to say don't do arbitration. I do a lot of them. In fact, I end up in more arbitrations, more cases going through a full arbitration than I do with trials. But in those instances, we try to be really, really careful about who we're selecting for our arbitrators, recognizing that we're not going to have a right to recover from a mistake that arbitrator makes.
Mike, a question for you from Dan Harvey. Does the owner get notified when a notice of contract is filed?
Yes. If it's a subcontractor, they provide notice that a notice of contract has been recorded. If a general contractor, you don't have a notice duty, but I would think you probably, I would think that in the ordinary course, you'd want to tell them for one of two reasons. If you're fighting with them about money, you're going to want to send them, the notice of contract as a shot across their bow to send them the message, we've taken this up a step. But even if you're not fighting with them, and as a general contractor under the mechanics lien statute, the statute envisions generals recording notices of contract before work even starts. That is, it's for a general contractor, not for a sub, but for a general, a notice of contract is not supposed to be a notice of conflict. It's a way of protecting yourself. And as long as you're signing partial lien waivers in exchange for getting payment along the way, even if the owner is funding the job through a lender, the lender is required to continue financing. So it's not supposed to be a notice of contract. I mean, a notice of conflict. But in that instance, if you're recording before you ever have a fight, I would think you would want to tell the owner and explain to them what you're doing so that you preserve the relationship. Otherwise, going back to one of my first slides, you're going to injure that relationship and it's going to lead to all sorts of future problems.
And this one's from Mark Behrens. Do you recommend binding arbitration?
It's a little bit of a misnomer. Arbitration, unless it's expressly stated otherwise, is always binding. What folks mistake a lot in terms of the terms is arbitration versus mediation. Arbitration, again, unless it expressly is stated otherwise in your agreement, is binding. You're stuck. You've got it. That's it. You don't have to say binding. It is binding. Mediation is the process whereby parties come together with a third party neutral who tries to get the parties to reach yes. You know, goes back and forth and tries to get each side to understand their various weaknesses and why it might make sense to make concessions, and tries to drive people to a point of mutual agreement, sometimes mutual disagreement, but a point they can at least swallow and sign off on. Now, mediation during the process it only becomes binding once you've signed off on a settlement agreement. It's not binding until then. In fact, it's not even something that is admissible in the future litigation. I hope that answers the question. Any other questions, Scott?
Not right now, sir.
Well, I think that about wraps us up.
Well, I'll be glad to see if anybody else has any questions. You can unmute yourself and ask away. We are over our time, but Mike is graciously giving us his time, so have at it.
All right. Hearing none, but Scott, if you get questions in the future, or folks should have my contact info, if for no other reason that it's on the article that you sent, but it's also on this on the PowerPoint, the first PowerPoint slide. I'm happy to talk with folks offline.
And several people have asked for your slide deck, so I'll make sure everybody on this call gets a copy of that and the link to this presentation.
Great.
And Mike, once again, really nice to see you, and thank you very much for your time today.
Thanks for having.
Great presentation.
Thanks for having me, Scott. I love being part of Bragby, and I look forward to doing this again in the future. Not only doing it in the future, but hopefully by this time next year in person.
I hope so too. And thank you everybody for being part of the event today. Appreciate your help. Thank you.